Dear viewers, today we take up a lesson on natural law, Greek and Roman legal philosophy. Natural law philosophy is that branch of jurisprudence which is concerned with the validity of the law rather than its structure or efficacy. Natural law philosophy has 25 centuries of history, right from 5th century BC to 20th century AD. There is no one theory of natural law. Many theories have evolved throughout this span of time. Natural law, which is also known as higher law or the law of nature, is the oldest as well as the most modern thinking in legal thought. It has been continually dominating the entire gamut of universal thought, whether politics, law, religion, and social philosophy. The term natural law has continuity, but this does not mean that the concept has remained static. It has had different meanings and has served entirely different purposes. As Friedman pointed out, the history of natural law is a tale of the search of mankind for absolute justice and of its failure. Again and again, in the course of the last 2500 years, the idea of natural law has appeared in some form or other as an expression of the search for an ideal higher than positive law after having been rejected and derided in the interval. With changing social and political conditions, the notions about natural law have changed. The only thing that has remained constant is the appeal to something higher than positive law. Natural law meaning and concept explained. Literally speaking, natural law is a body of laws that is derived from nature and is thought to be binding on all human beings. In legal theory, the term natural law means those rules and principles which are considered to have emanated from some supreme source other than any political or worldly authority. Various theories have been propounded since early times about the source, authority, and relation of these rules with law. Some say that these rules have come from God. Some find their source in nature, and others say that they are product of reason. Therefore, these rules have been given different names by different jurists such as divine law, moral law, natural law, universal law, higher law, ideal law, and so on. The term natural law, like positivism, has been variously applied by different people at different times. Diaz has tabulated them as follows. Ideals which guide legal development and administration. A basic moral quality in law which prevents a total separation of the is from the ought. The method of discovering perfect law. The content of perfect law deducible by reason. The conditions sine quibus non for the existence of law. According to the first meaning, natural law consists of certain ideals which guide the legal and political developments, such as concept of rule of law, natural rights, natural justice, etc. The second meaning refers to the intersection between law and morality. In the third and fourth meanings, Diaz had drawn a distinction between two kinds of natural law thought: natural law of method and natural law of content. The former was the older, dating from ancient times, and was also prevalent in the early Middle Ages. It concerned itself with trying to discover the method by which just rules may be devised to meet ever changing circumstances. It is a prescription for rule making, not a catalogue of rules. The natural law of content was a feature of the 17th and 18th century and was characterized by attempts to deduce entire body of rules from absolute first principles. The fifth meaning, as tabulated by Diaz, refers to the essential elements of a valid law. The following statements of Kelsen and Radbrush give an indication of some of the essential features of natural law. Kelsen, in his What is Justice, observed, the natural law doctrine undertakes to supply a definitive solution to the eternal problem of justice. To answer the question as to what is right and wrong in the mutual relations of men, the answer is based on an assumption that it is possible to distinguish between human behavior which is natural, that is to say, which corresponds to nature because it is required by nature, and human behavior which is unnatural, hence contrary to nature and forbidden by nature. This assumption implies that it is possible to deduce from nature certain rules which provide an altogether adequate prescription for human behavior. Nature is conceived of as a legislator, the supreme legislator. Radbrush, in his 5 minutes of legal philosophy, observed, there are principles of law that are stronger than any statute, so that a law conflicting with these principles is devoid of validity. One calls these principles the natural law or the law of reason. The work of centuries has established the core of them. The Italian jurist Del Vecchio aptly defines the legal concept of natural law. He observed, natural law is the criterion which permits us to evaluate positive law and to measure its intrinsic justice. In fact, the term natural law is analogous to bandstand with which a number of high ideals are mixed up. These are labeled as morality, justice, equity, ethics, right reason, good conduct, equality, liberty, freedom, social justice, democracy, etc. Natural law as such is not a body of actual enacted or interpreted law enforced by courts. It is rather, as Ernest Becker remarks, a way of looking at things, a spirit of human interpretation in the mind of the judge or jurist. It is this way of looking at things that is basic essential not only for Greeks and Romans, but for all. Because of its inherent superiority, natural law has always been regarded as a frame of reference to adjudge the validity of existing state of affairs, whether for maintaining status quo or for bringing about a radical change. In fact, natural law has been a double-edged weapon to conserve and protect whatever is moral, rational and just, and destroy all which is immoral, unjust and palpably wrong. Natural law has generally been considered as a humanizing and liberating ideal and utopia by oppressed people to challenge tyrants and to change unjust politico-legal order, as is evident from major revolutions that the world has witnessed. Visually, England in 1688, the United States of America in 1791, the Soviet Union in 1917 and India in 1947. Its forms and facets have been of varying nature, conditioned by manifold factors and manifesting diverse outcomes under different social, religious and political systems. The content of natural law has been differing from one era to another era. As Blackstone pointed out, this law of nature being coeval with mankind dictated by God himself is of course superior in obligation to any other. It is binding over all the globe in all countries at all times. No human laws are of any validity if contrary to this, and such of them as are valid derive all their force and all their authority mediately or immediately from this primordial basic law. Theories of natural law. Natural law theory, as pointed out earlier, has a history reaching back centuries BC. There is no one theory. Many versions have evolved throughout this enormous span of time. Natural law theory should not be dismissed simply on account of its variety. A brief discussion of natural law theories shall be presented in the historical order to give an idea of the various ideologies that it tried to establish from time to time and its effect on law. Natural law theories may be divided into 4 classes for the purpose of our study: ancient theories, medieval theories, Renaissance theories, and modern theories. Ancient theories, the Greek legal thought. Natural law thinking has occupied a pervasive role in the realms of ethics, politics, and law from the time of Greek civilization. If we start our survey of the legal theory of the Greeks rather than that of some other nation, it is because the gift of philosophical penetration of natural and social phenomena was possessed to an unusual degree by the intellectual leaders of ancient Greece. The legal conceptions of the archaic age of the Greeks are known to us through the epic works of Homer. Law at that time was regarded as issuing from the gods and known to mankind through revelation of the divine will. Law and religion remained largely undifferentiated in the early period. The forms of lawmaking and adjudication were permeated with religious ceremonials, and the priests played an important role in the administration of justice. The king, as the supreme judge, was believed to have been invested with his office and authority by God himself. A burial of the dead was regarded by the Greeks as a command of the sacred law, whose violation would be avenged by divine curse and punishment. Greek thinkers developed the idea of natural law and laid down its essential features. The Greek concept of natural law may be explained thus: animals act by instincts. Man, as part of the nature, must also have instincts which set passions in him. But he is something more than an animal because he is endowed with a will governed by an intellectual faculty which is called reason. Man's power of reason enables him to suppress his instinct and act against its dictates. He can act or not as he pleases. This faculty of reason is part of nature working in man. It inspires a sense of good and evil. It induces conduct which is consistent with good conduct and forbids evil conduct. The criteria which distinguish good from evil, right conduct from wrong conduct, are the instinctive laws of nature. Natural law as restraint of power. The instability of political institutions and frequent changes in law and government in a small city-states of Greece made some jurists to think that law was for the purpose of serving the interests of the strong and was a matter of expediency. Against changing governments, arbitrariness, and tyranny, philosophers started thinking of some immutable and universal principles. This gave them the idea of natural law. Thus, natural law was evolved as a restraint of power. Heraclitus. Heraclitus was the first Greek philosopher who found natural law in the rhythm of events. He turned to nature to say that in nature all things, sun, moon, seasons, plants and animals follow a certain definite order, and deducible therefrom that nature must have rules for the orderly conduct of everything, and therefore for man too, and it must be ideal law. This led to a conception of natural law as the higher law, which the Greek philosophers declared should be the model for all man-made laws. Socrates. Socrates was a great inquirer of truth and moral values. He said, "Virtue is knowledge, and whatever is not knowledge is sin." A very systematic and logical expression of the idea we find in Socrates. He said that, like natural physical law, there is a natural moral law. Man possesses insight, and this insight reveals to him the goodness and badness of things and makes him know the absolute and eternal moral rules. This human insight is the basis to judge the law. Socrates did not say that if the positive law is not in conformity with moral law, it could be disobeyed. Perhaps that was why he preferred to drink poison in obedience to law than to run away from the prison. Plato. Plato expounded his theories of justice and the state in the Republic and the Laws. In Plato's philosophy, a clear-cut distinction is there between his thinking about justice and his ideas about law. His approach to justice was metaphysical, based on divine inspiration. This confounded law with religion and morality and made law as a matter of faith and belief. Justice meant in Plato's view that a man should do his work in the station of life to which he was called by his capacities. Every member of society has his specific functions and should confine his activity to the proper discharge of those functions. Some people have the power of command, the capacity to govern. Others are capable of helping those in power to achieve their ends as subordinate members of the government. Plato says, to mind one's own business and not to be meddlesome is justice. Plato realized that even in his ideal commonwealth, disputes will arise which must be decided by the public authorities. It is the theory of the Republic that in deciding such controversies, the judges of the state should have a large amount of discretion. Plato does not wish them to be bound by fixed and rigid rules embodied in a code of laws. The state of the Republic is an executive state governed by the free intelligence of the best men rather than by the rule of law. According to Plato, justice is to be administered without law. The non-law state was upheld by him as the highest and most perfect type of government. Its effective operation required men of the highest wisdom and infallibility of judgment. Aristotle. It is in Aristotle that we find a proper and logical elaboration of the theory. According to him, man is a part of nature in two ways. First, he is the part of the creatures of God, and second, he possesses active reason by which he can shape his will. By his reason, man can discover the eternal principles of justice. The man's reason being the part of the nature, the law discovered by reason is called natural law. Natural law is inherent in the nature of man. As nature is common to all races and nations, natural law must be the same for all. Aristotle's contribution to legal theory were considerable. He conceived man to have a dual character. As part of nature, man is apt to act under instinctive emotions, but he possesses a will of his own by which he can master nature and control his emotions according to his notion of right and wrong. He conceived natural law as inherent in human reason and as the ideal to which all other laws should conform. He declared a law to bind not only the people but the government as well. He stressed the need to supplement law with equity. Whenever a general proposition of law is found to work hardship in particular circumstances of a case, equity must be applied to mitigate and rectify its harshness. He drew a distinction between distributive justice and remedial justice. The former connotes equal treatment of those equal before the law. Distributive justice has to classify persons as equals and non-equals. Injustice would arise when equals are treated unequally and when unequals are treated equally. The practical significance of this proposition would depend on who are treated as equals before the law. It had long been held that free men and slaves were not equals, nor blacks and whites, nor men and women, and with such discriminations, equality for equals was held to rule. Even under Article 14 of the Constitution of India, courts have upheld classifications of different groups as equals and unequals. He says, of political justice, part is natural, part is legal. Natural, which everywhere has the same force and does not exist by people's thinking this or that. Legal, that which is originally indifferent, but when it has been laid down is not indifferent. He made a useful distinction between natural justice, which is universal, and conventional justice, which binds only because it was decreed by a particular authority. However, the question as to the legal consequences of a collision between a rule of natural justice and a positive enactment of the state is left unanswered by Aristotle. He clearly admitted the possibility of an unjust law, but he does not say categorically that positive law which conflicts with natural justice is invalid. An incisive change in Greek legal thought took place in the 5th century BC. Philosophy became divorced from religion. Law came to be regarded not as an unchanging command of a divine, but as a purely human invention, born of expediency and alterable at will. The concept of justice was likewise stripped of its metaphysical attributes and analyzed in terms of human psychological traits or social interests. The thinkers who performed this transformation of values were called the sophists, and they may be regarded as, according to Bodenheimer, the first representatives of philosophical relativism and skepticism. Thus, the philosophers and sophists in Greece developed a general omnibus theory of state, society and law as philosophers rather than as jurists. Ancient theories, Roman legal thought. In Rome, Stoics built up on the theory of Aristotle, but transformed it into an ethical theory. According to them, the entire universe is governed by reason. Man's reason is a part of the universal reason. Therefore, when he lives according to reason, he lives according to nature or lives naturally. Stoics used their famous phrase, live according to nature. The laws of nature are of universal application and are binding on all men. positive law must conform to the natural law. The Stoic philosophy greatly influenced the Roman theory of natural law. Although the Greek philosophers and Stoics expounded the doctrine of higher law of nature based on reason in the philosophical sense, it was Romans who explained natural law as lawyers and jurists in a legal manner. Romans gave practical application to natural law. Roman jurists contributed for the scientific development of natural law strictly on legal basis, which finally resulted in the famous code of Justinian. By the time of Justinian, the Roman jurists were able to distinguish the jus natural, the jus gentium, and the jus civil. Julius Stone rightly pointed out that natural law with the Greeks remained a philosopher's speculation, whereas at Rome, natural law was given a revolutionary role in legal development. The creative period of natural law commenced when the Roman praetors began their compilation of jus gentium. The jus civil of the Romans applied only to the Roman citizens. It did not apply to the foreign settlers in Rome or to other parts of the Roman Empire. The Roman praetors made use of the jus natural as a universal law to apply it to all non-Romans. They adopted the usages and customs which were commonly observed by different people and were consistent with moral reason and were also in consonance with rules of the jus natural. Thus, they developed a code of laws applicable to foreigners under the name of jus gentium. In later ages, the jus gentium was used to moderate the rigidity of the jus civil and convert it into a refined legal system, which became subsequently a model law for many legal systems of the world. Natural law has been the principal instrument in the transformation of the old civil law of the Romans into a broad and cosmopolitan system. Thus, Roman jurists used natural law to modify, to refine, and to expand their laws. Cicero and the natural law. Cicero, in his work The Legibus, examined the basis of law. His major contribution to jurisprudence rests upon his concept of nature as providing a source of rules by which man ought to live. To him, law is the highest reason implanted in man. The highest form of reason may be discovered in nature. Law is the standard by which justice and injustice may be measured. Cicero stated, "True law is right reason in agreement with the nature. It is of universal application, unchanging and everlasting, and there will not be different laws at Rome and at Athens, or different laws now and in future. But one eternal and unchangeable law will be valid for all nations and all times. It is a sin to try to alter this law, nor is it allowable to attempt to repeal any part of it, and it is impossible to abolish it entirely. God is the author of this law, its promulgator, and its enforcing judge." According to Cicero, natural law is universal and immutable. It is higher law and is discoverable by reason. Cicero's enunciation of the principles of law related to nature and reason became a fundamental principle for jurists who sought standards beyond those of the positive law. Cicero influenced the discussion of natural law for many centuries to come. This lesson is a moderate attempt to enunciate the essential characteristics of natural law as articulated by the ancient Greek and Roman philosophers.